Everyone for coming to today's webinar and joining us. My name is Armando Ortega. I'm the Director of Product Marketing at Replicant. Replicant is a leader in cloud-based time tracking applications, and we have over 7,800 customers that use our solutions for tracking time and attendance and labor compliance. And today we're very pleased to sponsor the webinar entitled Contingent Workforce and Joint Employment Issues. And we're very happy to have Brian Dixon with us of Littler Law Firm, who's going to be joining us to present this webinar. Contingent labor has been a very hot topic in recent times. It's something that a lot of organizations have had to use more to remain agile, to expand capacity, and to have more flexibility. However, there are a lot of regulations and compliance considerations to take into account when using contingent labor that many people don't always know about. And organizations can get into a lot of trouble if they don't follow these closely. And so that's why we're very fortunate to have Brian to help us sort through this today in this webinar. However, before we get started with the program, I did want to take just a few minutes to take care of a few housekeeping items. First, let me tell you how you can participate in today's webinar. During the webinar, you'll be kept on mute. But you can continue to submit your questions at any time during the presentation by using the questions text box that's located on the right panel of your screen. We'll be addressing questions at the end of the webinar. We're going to leave time for people to ask questions to Brian and get some specific answers to some of those questions. Secondly, I'd like to remind everyone that you are eligible to receive HRCI credit for attending this webinar. It has been approved for recertification credit. You'll be receiving an email with the certification information. Please stay on for the complete webinar in order to receive this credit. We'll also be sending you copies of the presentation, and this webinar will be recorded. So, without further ado, let me introduce our guest speaker today. Brian Dixon is a shareholder in Littler San Francisco office and the co-chair of the firm's nationwide wage and hour practice group. Mr. Dixon is a graduate of Stanford University School of Law and has served on a wage board for the California's Industrial Welfare Commission. Mr. Dixon provides a full range of counsel and representation with respect to employment and labor matters. His particular expertise is disputes regarding minimum wages, overtime, prevailing wages, and incentive compensation. Mr. Dixon is the author of the Federal Wage and Hour Laws published by Shuram and the general editor of the Wage and Hour Answer Book, as well as has published many other works and publications. So at this point, I'd like to go ahead and turn it over to you, Brian, and please take us through the presentation.
Thank you, Armando. It's always a pleasure to work with you and many other individuals at Replicant and their clients to implement effective timekeeping solutions and project management solutions for the modern age, shall I say. And if we could go on to the next slide, I'll explain a little bit about what we're going to be discussing today. As an initial cautionary note, independent contractor, joint employment, and contingent workforce issues can be very modest in scale with a single employee, or they may entail many contract workers over a broad span. One of the things that makes this area very challenging is the fact that all of the tests that tell you whether you have a contractor or a contract worker or an intern or volunteer who's not an employee, or the opposite, consists of multiple factors, and those factors may, in a given case, point, as they usually do, some in one direction and some in the other. So a great deal of judgment is required when we get past some of the more basic issues in this area. And I do caution, of course, that where we have multiple factors going in different directions and ever-growing consequences, that you get the advice of counsel before, especially taking on a larger scale issue where you might actually not just be thinking about what are the terms of the contract that we're looking at, but how do we structure the relationship itself. The agenda for today is to talk about the difference between employees and independent contractors. This is an issue of ever greater importance given the federal and state government's perception of there being a very large underground economy of individuals who should be employees and TS should be paying employment taxes to support the government, and who are not treated as that. And also there's a concern on both the federal and state governments levels that those individuals are denied the benefits of such things as workers' compensation, unemployment insurance, and those states that provide it, state disability insurance. We also have joint employment, which you might slightly tongue-in-cheek subtitle as "When Are Your Problems My Problems?" And that is when do two entities stand in the role of employer to a given individual. We have, we'll talk about interns and volunteers, which again with a small dose of tongue-in-cheek humor might be, when are you, at least in theory, no one's problem because you're not an employee. And we'll talk about the consequences of misclassifying individuals. And there is a question and answer function here in the webinar room. I encourage you to use that, and if you have questions that you'd like to ask beyond or outside what we can get to here this morning, please feel free to email me at the address there in the presentation. Let's go on and look at consequences. We probably have consequences in the back of our mind, which is why we're here this morning, but we want to realize if we're looking at someone and thinking, you're not my employee, and they turn out that it is in fact your employee, we have minimum wage and overtime issues. One of the things that contractors are often paid is by the hour or on some basis other than the salary that's necessary to be overtime exempt, and as a result, someone who might otherwise be exempt, who's in a quote-unquote consultant role, would be due overtime. And we want to realize that the world separates itself out into two categories. There are employees and there are non-employees. There is no middle ground known as a consultant. We may use that term, but if we're thinking of consultant, we need to clarify in our discussion with our colleague or perhaps the consultant him or herself whether we think of you as a consultant employee or a consultant contractor. We, of course, have employment taxes on payments to workers. Very often, these issues arise as a result of a relationship that's ended with a worker. The worker files an unemployment claim that triggers the tax audit. Probably the most common way these issues come up. Health and retirement benefit issues are ever larger for us today. The Affordable Care Act introduces new non-discrimination obligations in the field of provision of health benefits. We have had those historically with respect to retirement plans. We want to realize that if we have a large number of contractors who are not appropriately classified, they are in fact your employees, adding when the IRS does an audit, and we'll see more benefit compliance audits in the future, the addition of a large number of, if they are lesser paid workers as employees, could make you fail the non-discrimination test. And of course, the consequence there is all of a sudden your 401k plan is no longer tax qualified. You have to wind up paying additional penalties under the ACA. Workers' compensation premiums and penalties often, probably the second most common way one of these issues arises is a worker gets injured, doesn't have health insurance, files a workers' comp claim because they have no other remedy, and all of a sudden another state agency is knocking on the door. We can also have, as to workers that may find it convenient to solicit being a consultant in the independent contractor sense because they may not at this point in time have the lawful right to work in the United States. Of course, you don't have to get an I-9 from a contractor, but you do from an employee. And then, of course, there's always the failure to afford the many, many other rights that are accorded employees, but not contract workers. Employees get jury duty, so you could terminate, of course, the contractor if they don't show up because they've been summoned to court. And if we can go on to the next slide, we'll take a look at employees and independent contractors. And rolling forward one more time, we want to be aware that we have different tests on both the federal level and the state level. And this is, if I should say it, a theme of the presentation this morning, and that is that the tests that arise under a given law can vary substantially in their breadth. And we see that both at the federal level and state level. And if you multiply all the tests, you can have quite an array of factors to consider. And it is theoretically possible for an individual to be a contractor under some laws, but be an employee under others. The most narrow of these tests is the common law test for employment. You see that under the Internal Revenue Code, ERISA, OSHA, and the NLRA. There's the FLSA economic reality test. There are definitions of employees and other worker protection status that may be broader or narrower given the case. They're also on the state level. Of course, we have state tax obligations, workers' compensation at the state level, unemployment insurance, wage and hour obligations created at the state level that include tort law, wage and hour laws. Question whether a state will pursue the economic reality test that we have under federal law for wage and hour issues. And then we have what's known as the ABC test, which is a test used by statute in a variety of states to determine when an individual, and most commonly used to determine whether workers' compensation premiums are due and coverage is due, and whether unemployment taxes are due. If we could go to the next slide, the most common test that's used is the common law test, and that is the right to control test. And you might think, well, gee, how can I do anything without some right to control? And we have to draw a line here between the right to determine the result. I need this done I need the house painted, so to speak, by July 1st, because the in-laws are coming shortly thereafter, versus the control how we're going to do it. How many painters will you have? Will you use scaffolding or a ladder? Will you use paintbrushes or spray it? All of those things talk more about the manner and means of getting the job done. And various factors are considered to determine whether it's the right to control. Life would be a lot easier if it was simply, do I have a right to control reserved in the contract? We want to, again, remember it's the right to control, not the exercise of that right, that will make someone into an employee as opposed to an independent contractor. And there's I point out here, there's the IRS 20-factor test, and the IRS test calls out most of the things that are common under the state right to control test, the right to control test that's used by other federal agencies besides the IRS. The 20 factors are available in a very handy form called the S8 form. That's S as in Sam, S as in Sam -8 form. And I have to say that very often when I talk to a client about a contingent worker or independent contractor issue, I will simply download the form and use that as an outline of the conversation. Don't be afraid to go to the website. The IRS does not automatically audit everyone who taps into the website. In fact, that form is a very handy resource. We're going to talk about those 20 factors because they are, again, used not only by the IRS but by other agencies to determine whether we have an employment relationship or not. And again, we're talking about the right to control test. And the IRS divides the 20 factors into 3 broad categories, which are also handy to bear in mind. They are behavioral control, financial control, and the relationship with the parties as they have formalized it. So let's look at behavioral control. The facts which illustrate where there's a right to direct or control how the worker performs the specific task include whether you give instructions and training to the individual. Certainly if you're training someone, you're telling them how to do the job, and that's a rather obvious aspect of the right to control. Telling someone where to work and when to work, we might think, well, we all have deadlines, and of course the deadline is not telling someone where and when to work, it's just to get the milestone accomplished by the given date. So we need to be attuned to the fact that if we're scheduling someone, it often raises the risk. It's one of the indicia of control that we have to consider. And, just as an aside, I'd like to pause for a second and point out that these issues exist at all levels of the workforce. One of the things that I've run into several times in the recent years is when the chief financial officer of an organization, perhaps more attuned to finances and paying taxes and the desire to limit within available means taxation, is engaged as an independent contractor, even though that individual has an office next to the CEO, has a business card that says, I am the CFO of the organization, may be paid a salary, may not have any other, apart from maybe some personal financial issues, has no other consulting relationships. And you have to appreciate that this issue is one that would apply equally well at that level as it would to any other level of the organization. So let's go ahead and look at financial control. certainly if you have a worker who has a significant investment unreimbursed and you don't reimburse their expenses, and you're paying them by the task instead of by the hour or on a salary basis, you'd say, well, how does that relate to the right to control? Well, that's an indicia of independence and the ability to take one's business elsewhere. And one of the things that I would encourage everyone to do is when you're looking at your basic worker issue, you want to think of it in functional terms. If you, for example, have an individual who you want to engage as, and I'll pick a simplified example for the sake of making the point, to do the landscaping around the plant or the office or the factory, and you find someone who perhaps has worked for the organization or has the job of the organization now and wants a little extra income, and you say, okay, fine, we'll provide the lawnmower, we'll provide the fertilizer, we'll provide the tools, the equipment of the trade, and we'll sort of schedule around your existing schedule as an employee. You have to go and look and say, what's really different there? And very, very little is different there. If at the same time you take the same job, the same undertaking, and you engage someone who perhaps has gone a little farther down the path and they've been successful at getting a couple of landscaping jobs, and they now have a truck that says, Landscaping Services LLC on the side of it, and they have their own mower and their own equipment, and they said they are happy to do the premises once a week, but we'll sort of work out jointly what day it might be. You can see how doing the same thing can be very different in terms of whether someone's a contractor or an employee. And that leads to one, I think, important tip, and that is when you're engaging a contractor in circumstances where, we really don't, for whatever reason, we don't have the budget in the headcount side of things, we have some other institutional interests that suggest that we don't want to have an employee here, who you choose as a contractor can make a real difference in whether you have a successful relationship or not. One of our rules of thumb, of course, is that you don't want to have someone who was an employee of the organization as a contractor within the same calendar year, because the IRS scans to see whether or not there are W-2s and 1099s for the same individual from the same organization in the same year. And as a practical matter, that's a good thing for the IRS to be doing, because it's very hard for someone to go from being a full-time employee and, the employer provides all the facilities, tools, equipment, exercise the right to control, to boom. The next day, maybe I've retired, I've done so voluntarily and with great desire, but the company wants to keep me as a consultant, and all of a sudden I'm a contractor the next day, but nothing's really changed. I'm coming back to the office doing the same thing. I have no other customer. More importantly, I have no other customers. I have no independent business. I have no business organization. Again, who you select can make a large difference. And we talk about the relationship of the parties. I have to say that one of the things that I spend a great deal of time doing is helping clients develop not just a written contract, but a relationship that will withstand scrutiny, as whether it's a contractor or an employee. And, a contract is not a magic wand. There is no contract that I can write or anyone else can write that will turn someone who is functionally, again, the test is functionally an employee, into a contractor. Your contract will not turn Cinderella's pumpkin into a carriage of independent contractorness. So, in some regard, the contract is a weak indicator of whether someone is a contractor or not. But a poorly written contract can condemn a relationship that might otherwise survive scrutiny into employment. If, for example, there's a right to control, or the way that someone is paid is structured such that you submit a timesheet and we pay you every 2 weeks on the same payroll schedule as everyone else, we need to be attuned to the fact that a poorly written contract can destroy a relationship. And of course, provision of employee benefits is going to make someone look like an employee, and as I said at the outset, today, where the integrity of benefit plans is ever more important, the last thing you want to have is independent contractors inside a benefit plan that's intended for employees. The ability to terminate at will is also seen as strong indicia of control. And the courts are savvy to that, shall I say, in the sense that if you have the ability to terminate a contract at will, without cause, without breach, then the courts will infer that your suggestions your mere suggestions as to how that contractor might do the job a little bit better will be seen as commands because the contract could be immediately terminated. So we've talked about the right to control test, and again, that dominates the field of independent contractorness, and when clients talk to me about contingent worker and independent contractor issues, that's very often where they start, but we need to realize that the Fair Labor Standards Act, passed in 1938, the worst year of the Great American Depression, has a different and much broader definition of when someone is an employee. And it would have been really nice if Congress had defined an employee in something approaching more functional or practical terms that we might apply. But if you look at the definition of an employee here, you might, which is the middle bullet, an employee means any individual employed by an employer, think that it's slightly circular, and I would have to agree. That issue has been spinning around in the court since 1938, and even this year, the Supreme Court was struggling once again with what is work, because work is what makes someone an employee, and the issue perpetuates itself. The Supreme Court really confronted this issue for the first time in the mid-1940s, 1947, and they developed what they call the economic reality test, and that is less a scrutiny under the common law right to control test, but whether someone follows in the broader sense the usual path of an employee. So what we see are often many of the same factors that we would find under the scrutiny of an individual under the common law test, but what we really have is a change in emphasis. And let's go ahead and look at the factors that are commonly used, and they include the services rendered are an integral part of the business. You know, if this is a core function of the business, the court will infer, or a decision maker will infer, that in fact you have a substantial interest in how that should work out, and they may infer employment. Certainly the degree of control is always going to be there. It's a significant factor. Whether the relationship is ongoing or not. If you contract out, for example, the receptionist function, you can imagine that we always need the receptionist. We're probably going to need a receptionist for a long period of time, and receptioning is, in some regards, a essential part of the business. We have some interest in how the receptionist is portrayed by people who come through the front door. The amount of investment in facilities and equipment, and here we begin to see the shift from right to control on to more in the way of economic reality. And that is, in many regards, could someone stand alone as a business, and therefore do they have sufficient, integrity as a business not to be dependent upon an employer and therefore to be entitled to the minimum wage and overtime. And the dependency factor is interesting. I once described this test to a medium-sized business. Had been developed by one individual. I had been quite successful. And I talked about economic dependence, and he was a government contractor, and he said, heck, that's the test. I'm an employee of the United States government because I am 100% dependent upon the government. And it did take a little bit of talking to distinguish the fact that, given the number of employees he had in his independent office, if worse came to worse with the United States government, he could offer his services elsewhere. But I think that example does point to the fact that there's just an increased amount of uncertainty when we apply the economic dependence test than we do when we apply other tests. And towards the end, we begin to see some of the other things that really make the economic test different than the tests that are applied in other contexts. We look at the amount of initiative, judgment, or foresight and open market competition required for success, degree of independent business organization, and opportunities for profit and loss. One point of confusion that I often encounter with clients is the opportunity for profit and loss. They say, well, look, if you work harder, you can make more widgets and you'll have, have more income. But we're really talking about true profit and loss, and that is the ability to organize a function in a fashion that will produce a greater return, the ability to be more efficient or to do simply a brighter, shall I say, job and be rewarded by a higher rate of pay will not get us there. Just won't. I think one of the best examples of the economic reality test, and also what I would call the functionality, is a case involving shore-way cleaners. This was decided some years ago here in the Court of Appeals for the Ninth Circuit. And on the face of it, this seems like an implausible employment relationship. A company owned a number of dry cleaning outlets. It had owned the premises, storefronts in small mall settings, and they also owned a dry cleaning plant. And they would offer leases of the dry cleaning storefront operations as businesses and to an individual, and you'd sign the ground lease, and it looked, for all intents and purposes, like it was your business, and you could take in dry cleaning and charge clients and be rewarded for your services. But the court began to parse what the lease really did. Among other things, as part of the lease, you had to have all your cleaning done by the lessor's cleaning plant. You didn't have the opportunity to go elsewhere to get either a higher quality or a lower price job. You were required to keep the storefront open for certain hours. The prices that you could charge were regulated by the lease to be those which were determined by the dry cleaning plant, and you could not release the premises to anyone else. And the court eventually said, you know, while on the face of it, this would be something that would probably pass muster under the right to control test, as a matter of economic dependence, the individuals who sign these leases are essentially bound to a relationship that looks very much like employment. There's really no property interest here. What it is an agreement to, as they characterized it, to take in dry cleaning, have it processed, collect the funds necessary to be paid for it, and punch out, so to speak, at the end of the day to come back the next day. A good example. And if we can go on to the next slide, we'll talk about the ABC test. And the ABC test is, again, used in a fair variety of states in order to, it was originally developed to simplify and to a degree broaden when workers' compensation and unemployment insurance would be available to workers. And you can see here a small a token reference to direction and control, but the two final factors are important. The services are outside, of course, the usual business, and you have some form of independent business organization. And if you look at these three tests on a continuum, you have the right to control as probably the narrowest test of when someone is an employee. Economic reality is a much broader test, and then the ABC test is even broader than that in terms of whether an individual is an employee or not. And before we leave independent contractors and we start talking about joint employment and then about interns and volunteers, I'd like to offer another example. And here I will go from functionality to what I will call transparency. And let's look at another circumstance. This is actually a case that I litigated on behalf of a logistics company some years ago. It's a published court decision. And the logistics company undertook to deliver furniture. And their business model was we don't engage drivers with trucks. We don't hire driver employees. We manage the delivery process for you, and we subcontract all of the delivery services under written contract, which, among other things, required one to produce. To have any contractor had to have a truck, had to have a helper, had to have insurance, and had to have a PUC license. So, you know, on the face of it, it looked like a fairly robust independent contractor relationship. And the state attacked it, and the state's points were these, and that was that a couple of other little businesses had grown up around the logistics company. If a, quote, applicant to become a contractor went, quote, down the street, they could go to a truck leasing company and show the contract with the logistics company, and the truck leasing company was very happy to do business with these individuals because they had what they thought was an insured source of income. So you could readily lease the truck. You didn't have to buy a truck. You didn't have to have an investment in the truck. You could get a maintenance contract to go with the truck as well, just for a few extra dollars a month. And while the term of the lease was nominally 1 year, as it turned out, if you, just in the interest of good customer relations, if you ended your relationship with the logistics company and came back and you turned the truck in, as long as there was someone, quote, in line behind you, then they would just excuse you from the balance of the lease term. And if you went up the street instead of down the street, you could find a friendly insurance broker who also thought very highly of the this relationship and the logistics company's efforts, and you could get general liability insurance instead of, by the year at a substantial premium, by the day, or even by the number of days you worked. So the risk was further diminished. And of course, things being what they are, it was fairly easy to pick up a helper at the gate to the warehouse in the morning and have someone who would be there to help. So things, on the face of it, looked a little, when we looked at the transparency factor, we're looking a little challenging. But one of the great things about this was one of the witnesses I called who said, I started with one truck, and I had a helper, and I have to say the first couple of years were sort of grim. But I have to say that this is a relationship that could work. And so I bought a second truck, and I got initially one of my in-laws, and he got a helper. And then as things would go on, I sort of made sure that my folks did a good job, and then I got a third truck, and now today I have 9 trucks. And, there are a variety of these logistics companies out there, and I just float my trucks back and forth from one to the other depending upon who's offering me the best deal. And this fellow who had was actually arrived in the United States not that long before he first started working for this company, had become his own little independent trucking company and still provided services to this logistics company and other logistics companies. And that was, it was actually quite a heartwarming story to present. The judge thought of it as that. I actually think one of the more interesting things about this is while the state was attacking this relationship and had a couple of disappointed drivers to support their case, most of the drivers, when they came into the courtroom, would sit behind the company's defense table. I think also a factor which the judge probably silently noted as, this really isn't an exploitative relationship. And why don't we press on? If you could look at the next slide regarding employees and joint employers, we'll start on this, our next subject, and let's go ahead and look at joint employment basics. What does it mean to be a joint employer? Well, in some regards, it is your problems are my problems, or my problems are your problems, as the case may be, depending upon which side of the coin you're looking at. When you are deemed to be joint employees, and you can be joint employers, you can be joint employers not only for wage and hour issues, you can also be that for benefit issues, you can be that for liability for harassment issues. So we need to realize that joint employment means full freight in terms of the potential risks that you face. The most common scenario where joint employment comes up is in the paycheck issue, the paycheck arena, the wage and hour issue, and that is if 2 employers are joint employers, then all of the hours worked for both employers have to be summed to determine whether, in fact, overtime is due. And, for example, if you have a temp employee who works for you and you're a joint employer with a temp agency and that temp works at 3 or 4 or 5 other places in the course of the week and gets well over 40 hours or over the daily overtime threshold, you have to make sure the temp agency is paying them based upon total hours, or you could have a potential liability along with the temp agency. We'll come back and talk about the most common scenarios in terms of joint employment in just a moment. But the important thing is to realize that joint employment means in the wage and hour arena that the hours get summed for the purpose of determining minimum wage and overtime compliance purposes. And equally important, both joint employers are equally liable to the employee. The employee doesn't need to sue both, doesn't need to sue the employer of record. If you are, as a matter of law, one of those joint employers, the employee can obtain a full remedy from you alone. And you might be thinking, well, darn, we have this nifty indemnity agreement in the contract with the temp agency, and they promise to take care of any potential issues we have, and that may well be the case, and you'd want to have that there, but there are 2 important things to remember. One is that that indemnity clause has no influence over the employee and who the employee can pursue in terms of a remedy. The second is that any indemnity clause is only as valuable as the pocket on the other side is deep. and I've had a number of cases where a temporary services agency was paid by all of its clients and then for just reasons beyond its control filed bankruptcy before it got the last round of paychecks out, and all of a sudden you have the temp agency employees coming back to the employer for whom they work saying, you got to write that check a second time. Certainly an unpleasant set of circumstances. So let's go forward one more time and take a look at the most common joint employer scenarios. And those are that an employee may work simultaneously for two entities which are unrelated, which is great. More power to them. You've got to give them credit for the gumption. And you say, what's the matter with that? And the answer is nothing if the two are truly unrelated. And then you have scenarios where an employee works simultaneously for two entities which are related. And these are probably the most challenging joint employment issues. They arise in every shade of gray and every other color you can think of: green, violet, orange, red, white, blue. One simple scenario is I work for Hospital A, which is part of a chain, and there's Hospital B, which is part of the chain on the other side of town, and I also, I decided to supplement my income, and maybe I'm a part-time employee here, and I'm on the per diem list over there, and because they're commonly owned, do I have joint employment? And a very difficult scenario. We'll look at how the Department of Labor might resolve that in a moment. Another scenario is perhaps I am an employee of a service company, and I provide services to ABC Manufacturing Company, and ABC determines, the person who oversees that contract, decides that I'm really got a lot of moxie, a lot of good things going for me, and I eventually decide I'll pick up some hours by getting on the per diem list at ABC Manufacturing Company. So I'm a direct employee of the company and also an employee of the company that provides services. And yeah, do we have a mess? We do have a mess. And that's one of the things that you want to anticipate when you deal with a contractor and also with your own managers, and that is, we really want to avoid, and one of the lessons here obviously is when you have many shades of gray, best to avoid getting into too dark a shade of gray. And then we have the other circumstances where, for example, you contract out part of your operation, or in a sense you might contract all of your operation by virtue of being a CEO or using a leasing company. And here, and we're just going to spend a minute here, this is worth looking at and thinking about, is the Department of Labor's, U.S. Department of Labor's very broad definition of when joint employment exists. And you can see that just about any combination of common ownership and control is going to result in joint employment, and we need to be mindful of that when we look at the scenarios if I'm working at Hospital A and Hospital B and they're part of the same multi-facility hospital organization. One of the things that I always ask in that scenario when someone's saying, well, do we have joint employment is, well, does the employee have two sets of benefits from the separate entities? Well, of course not. You can only have one health plan. Well, what does that tell us about whether there's joint employment or not? And I would say it tells us a lot. We need to realize that the courts have developed different criteria for when an individual is a joint employee. You can see them listed here. I'll explore them briefly by providing this scenario. It's one that's been the subject of a good deal of litigation out here in the West recently, and that is, for example, if a landowner hires a farm labor contractor. And this example is not limited to agriculture. It's a prototype that can occur in many other scenarios. The garment manufacturer wants to create garments. But let's look at the agricultural scenario for no other reason that it's been the subject of a great deal of litigation recently. And the landowner may say, I don't want to just lease the land out. I want to be a grower. I'm going to grow the crop. I'll sell the crop at the end of the day, but I really don't want to be an employer of a large number of workers needed to accomplish that result. So I'll hire a farm labor contractor, and we'll negotiate, a pretty good deal, and I'm a tough negotiator, so maybe that number in terms of is pretty low in terms of the services that will be provided. And as most such contracts do, I'll let the contracting contractor hire anyone he or she wants to, but I'm going to have veto power in case somebody shows up that maybe I fired in the distant past, or darn, it's my brother-in-law, and I don't really want him around here right now. And then we have, this ability to supervise. And sure, because those are my crops, and at the end of the day I want to sell them at the highest price, I might have a foreman out there who sort of walks around and makes an occasional suggestion, and hopefully makes those suggestions to the foreman of the labor contractor and not to the employees of the labor contractor, because otherwise you're going to have shared supervision. Rate and method of payment, well, if I drove a really tough deal and the entire remuneration at the end is, dollars per ton, the contractor might be telling the employees it's a piece rate scheme and it's based upon pounds, and maybe I have a little bit of influence there. I don't maintain those employment records, but all of this work necessarily occurs on my premises because it's my ranch. And is this a large ranch? Then some of these people, the labor contractor, might be employed full time here. And you can see also in the labor contractor arena, excuse me, if you're just contracting for labor, a court may say, this isn't real. There's no separate independent business on the part of the labor contractor. So what we have are a variety of results, depending upon the individual details, as to when you might be a joint employer in subject for perhaps a default of labor contractor in terms of wages or failure to provide meal periods and rest periods and the like, or other benefits here in and these cases arise under federal law, so we want to realize that this model can take place across a wide number of scenarios. And lastly, let's look at interns and volunteers who are, at least in theory, not employees. Those of you who read the labor law news, of course, will realize that there are two very important cases pending in the Second Circuit Court of Appeals back in New York. Those cases arise out of media companies in New York, which are actually renowned for having many interns. Getting a job with a media company is, of course, a great asset, or even an internship is a great asset on someone's resume. And a cynic might say that perhaps some companies are trading on the need to have something on one's resume to obtain labor. I had a conversation with one of my great college friends' son last year, 2 years ago. And I said, what are you doing this summer? And he rather grumpily said, well, I'm an intern. I said, well, what's the matter with that? And he says, well, I get to do the same thing as all the employees. I just don't get paid for it. And so we need to realize that there is a difference. This is a subject that is the subject of a great deal of scrutiny by the United States Department of Labor right now. They have really stepped up enforcement around this. So how does this become different than employment? Well, interns and trainees are really people who are learning something. They are not there to do productive work. The learning factor might be indicated by whether there's academic credit offered. Is this person enrolled in school? Do they get academic credit? I have to say, internships have become so common that academic credit had become fairly common and not too highly restricted in a variety of scenarios. So I really look to see whether you have some coordination with the school. Is there a learning plan? If asked by a Department of Labor auditor, have you ever talked to the school that's offering academic credit? You should be able to say yes. And, structure is good. There are a lot of the internship plans that I've seen or internship disputes where the Department of Labor has arrived is we have interns every year, and we have, a dozen interns in different departments, and you ask the people in HR, did you ever talk to the supervisors about what it meant to be an intern, or do you have any written guidelines around this? And you'd be amazed at the number of times the answer is just no. So you want to structure the experience. One of the things that's good from a training point of view, of course, is if people move from department to department, and I set up a training program for a local TV station, and the one complaint we got from a supervisor was, just about the time these people are becoming productive, you keep picking them up and moving them away, and the answer is that's the whole point of the experience. You also want to make sure that your internship program is not specific entirely to your operation, but it provides more of general training. So let's go on and take a look, if we can, at the other criteria that apply in the internship arena. And the second one really is whether interns displace regular employees or work under close supervision. And of course, you don't want to think of interns as summer help or as help in peak periods. Someone who does the job, gets a hands-on experience, but only because the employee who's doing that is now standing behind them and that employee doing nothing else. We call that job shadowing. Of course, that will pass as non-employment. We also have some other criteria. These are the 6 criteria that the U.S. DOL uses. We want to realize they're guidelines. They are not cast in concrete. They are not regulations. There was a case recently in Colorado where EMTs would be offered a job if they would succeed as trainees, which of course would violate guideline number 5 here. The Department of Labor took umbrage to that, but the court said, you know, on balance, this really is a very valuable training program. People got good skills and experience. They could opt out of the employment relationship at the end if they wanted, or the offer of employment, so the court found it not to be determinative. Touch briefly on volunteers, and of course a volunteer is a volunteer. The distinguishing factor of volunteerism is that there's no real set of conditions around it. It's not like you have to show up every Monday morning in order to continue to be a volunteer, although certainly if someone doesn't show up regularly, you might get a little frustrated about that. There is, volunteerism really is dominated by a few factors, one of which is there's absolutely no expectation of compensation. There's no expectation this will become employment. There's usually what I think we call it missionary aspect to it, which is I'm trying to do good deeds, such as read to someone who might be in the hospital or entertain people who might be in a home for the aged or disabled. One important distinction to realize is that we can have volunteers in the nonprofit sector, but you cannot have a volunteer in the for-profit sector. Rather arbitrary line, but I have to tell you the Department of Labor will pursue it in every circumstance. One of the things that I've seen, the last bullet here really is a nonprofit decides one way to raise funds for itself is to gather together the individuals who work for perhaps a local charity, and the charity volunteers their services perhaps to the local theme park in order to run the parking lot on a weekend in place of, notice the in place of the regular parking lot attendance, and in exchange the quid pro quo is that the charity gets the income, and of course the Department of Labor has said that's not going to start, not going to fly. So really quickly, we need to realize there's increased enforcement. The underground economy has gotten a lot of attention. You need to realize that someone who's misclassified as a worker might be able to make a wrongful termination lawsuit out of just complaining about the fact I should be an employee if their relationship ends. Civil penalties, new civil penalty in California up to $50,000 per misclassified worker. See a lot more class actions. I've handled a few of those regarding whether, very common in the owner-driver context. And while we can go to the IRS website and get an SS8 form, we need to realize that the Affordable Care Act and ERISA continue to be really hot subjects of focus here on the part of the enforcement agencies. Now I'm going to turn the program back to Armando. And Armando, tell us a little bit about Replicant, please.
Sure, great, Brian, and thanks a lot for that great informative presentation. So we're going to be getting into the Q&A section here real soon. First, I wanted to just take a couple of minutes to give people on the phone who are not familiar with Replicant just a little bit of information about us. So we are the leader in cloud time tracking applications. You can see here the number of customers. We have over 7,800. We have millions of users that use us to manage their workforce attendance, but also do things such as manage their projects, programs, and also do a professional services and shared services management of those centers. Here's just a sample of some of the companies that are our customers, highlighting here just the level of diversity. We have both very large companies that are well known and established, as well as a lot of smaller companies that we also service and work with us. And generally, our companies come to us looking for these key things. One is they want greater insight into their labor. By tracking their time more efficiently, they can understand how their workforce is performing, what are the labor costs, and also handle a lot of the compliance regulations that deal with labor, whether that be overtime or meal breaks, some of the topics that Brian talked about. And also, I'll talk a little bit about contingent labor, how some of those places are relevant in a minute here. And then also just automating the process and eliminating all of the manual interventions, things that might be slowing the process down, like spreadsheets or other manual-based approaches, taking all those and automating them for better efficiencies. And this is the core of the time attendance version of our solution. So at the core, we have the time tracking capabilities, as well as that. We also take care of absence management, tracking time off for employees, vacation accruals, time off, sick leave, jury duty. We have a set of time clocks that can be deployed that are cloud-based. We handle scheduling, and then we have a lot of capabilities and configuration to help manage compliance for organizations. And so, I mentioned compliance, just a few things that come to mind with regards to the topic we have today for contingent labor. So a lot of organizations will rely a lot of times on the third-party temp agency or so, whatnot, that they're using and they're using them to log employee hours for their contractors, not for employees, but logging their contractor hours. But a lot of our customers actually like to take that and start tracking hours themselves. So this provides the benefit of having a centralized place where they can manage that and understand better how their contingent or contract labor is being used in the company. For example, the marketing department might be using one temp agency, while the finance department might be using another one, and you don't have that complete visibility. It also gives them the ability to ensure that they're reporting hours correctly, that they're monitoring how many hours these different contingent workers are spending to make sure that they don't exceed that threshold defined by ERISA, after which you really can't classify somebody as a contingent worker. That could have severe implications if you do that erroneously. We can impose things like specific validations or thresholds by defining a specific contingent labor employee type of user versus a regular employee and handle them differently. And a lot of companies use them to track their contingent labor costs against specific budgets. Maybe they've allocated a certain amount of budgets for specific areas for contingent labor, and they can do that effectively and make sure they stay at least compliant within their own organization and how they want to use contract labor. And then a lot of them use our project services. Sometimes if there's situations where you're not dealing with hourly, but it's more of a milestone-based approach, and you want to see how people are performing against results and when a payment is due, some organizations have also used it in that regard. So a few things, if you're interested to learn more about our product, there will be a webinar next week, February 12th. We'll be doing a quick 30-minute demo of our solution for those of you who are interested, and you can sign up on our website at replicant.com. And lastly, this is the first of compliance series. We will be having a whole series of 5 more webinars where Brian will be joining us. So we'll be inviting you and hope that you would join us. Today we talked about defining who is an employee and who isn't. March 6th, we'll be talking about, well, now that you've decided whether or not this person is an employee, how do you know what time is allowable for tracking for payment and for work? And so Brian will be talking about that in March 6th. So we'll invite you to join us for that as well.